my take is that law always lags behind technology. Technology today is growing at a very, very fast pace. Not only that, it is also getting diffused to the public at large, to the world at large, at a pace that was previously unknown. See, technology is cutting both ways. It is boosting trade, international trade. It's also ensuring that infringement and piracy takes place at a level which was previously unknown. It has blurred national boundaries today, and it is challenging certain basic concepts which we always believed in the intellectual property regime. For instance, we were always told and we always have understood IP law to be territorial. Now, suddenly with the boundaries gone, there is a lot of confusion amongst the lawyers, amongst the judges, because different countries follow different principles with regard to IP law. For instance, in some countries, the priority is given to first to use principle or on the first to use principle. While in other countries, it is first to file registration. Now, how will you reconcile this? Or some countries recognize the concept of transporter reputation, while others do not. Now, the main issue which a judge is confronted with in this new regime is issue of jurisdiction. For instance, you access an e-commerce website on the net. Where would the jurisdiction for the infringement action lie? There are various tests and different courts are adopting different tests, whether it's mere access, whether it is purposeful availment of jurisdiction, or it is minimum contact. There is divergence of view on that.
Okay, very similar situation in South Korea. I want to talk about very shortly. Online infringement are different than offline infringement in that they are not bound by territorial limit, and they happen in e-commerce platform. But it has been a while since online trade became common in South Korea. So these issues surrounding online infringement are not entirely new. And we've been dealing with cases without big problems so far. However, as the e-commerce sales, especially in the global online market, have grown steadily each year, these issues are becoming more important. This increase in volume of relevant dispute and their gravity is posing new challenges, calling for changes in legal principle. Possible solution to these challenges? How would I know? If I knew the answer, we wouldn't need this conversation. I hope get some hints from today's conversation. Yes, recently a Korean company filed an IP lawsuit against another Korean company in the US, not Korea. Perhaps it is because the amount of damage is larger in the United States in South Korea. Also, it is generally easier to collect evidence under the discovery system of the US. We don't have a discovery system. Some people, including government, seem to be taking it more seriously. Yeah, and recently there was a change in the act on private international law in the South Korea. In the past, there was no explicit jurisdictional rule related to IP cases. So the court had made a decision in consideration of each case's practical relevance to South Korea. But now there is a new rule to this. According to the Article 39, the Act, the lawsuit regarding infringement of IPR may be filed in South Korea in three kinds of cases: infringement committed in South Korea, the result occurred in South Korea, infringement committed toward South Korea. But also there is a limit to this. The lawsuit shall only concern the result that occurred in South Korea.